All right, good evening, everyone. And this begins the pre-meeting for the June 17th, 2021 Zoning Board of Appeals hearing. During the pre-meeting, board members go over cases with staff and ask any questions that they may have to get any last-minute questions, which will be followed by the actual hearing, which will begin promptly at 6 p.m. So all board members have received the additional public comment that came in for a series of cases. They have reviewed it. All public comment has also been posted on the city's website for public inspection. And before we get started with case number 1 and going over site visits, Johanna, I wanted to address the inquiry that had come in from Mr. Lembach with the board about potential defects with the posted notice requirement of the zoning code. So as everyone knows, the City of Rochester zoning code has a series of requirements for notification as a means to try to generate public feedback. Some of that includes publication in the Daily Record, publication on the city's website. All property owners within 600 feet receive a postcard, as well as the official neighborhood contact that is on file with the Neighborhood Service Center. And a sign is also required to be posted on the property 20 days before the hearing so that it is visible from the right of way. The zoning board had received comments regarding 3 of the cases where a combination of not having a sign posted as well as sign posted but not terribly visible could have been better posted. So Johanna, as legal counsel to the zoning board, has notified everyone that the code accounts for, of course, all of the requirements for notice, as well as potential minor defects in the notice of requirements. So what that looks like to a board is this. You all have the opportunity to inquire with the applicants about the posted notice sign or any of the notification that you have questions about. And try to find out more information. Was the sign posted? Was it not posted? Where was it posted? Was it visible? Find out that context, and then the 7 of you have that ability to determine whether or not, a minor defect occurred with the sign. We can vote on this, or there, actually was a defect to the point that it was not minor, and maybe this should be adjourned and heard at a later date. So that gives you the opportunity to discuss that with the applicant. And then make that decision during the hearing. Does that make sense to everyone? Does anyone have any questions?
Wait a minute. No. Is that in lieu of all the other notices that everyone receives?
Well, nothing's in lieu of. They're required to, we do everything, right? So they're supposed to post the sign. We send out the postcards. The neighborhood contact gets it. So there's a series of required notifications.
I get that. But so we can basically say just because of one notice maybe is in question, that person cannot basically defend their position at a meeting. Is that correct? Or am I not?
Yeah, I mean, what I would suggest you do, you look at the whole picture and you ask the applicant what the notice that they were responsible for was the posting. The city took care of the publication notice, the mailing notice, and putting on the city website. What they were responsible for was posting the notice. And so the inquiry that you need to make to them, if there's a question about whether that was done properly, is ask them, what did you do? Did you post the notice? Where did you post it? When did you post it? If you are satisfied that they made a bona fide effort to do the correct posting and the actual location of the notice, I think in one case was suggested that it wasn't terribly visible. You will have been out to the property. You can judge for yourself whether that was so hidden that it was not reasonably posted or whether it was adequate. So it's sort of it's a judgment call on your part, whether they met the requirements or whether this was a minor defect in the posting requirement.
Got it.
Okay.
Thank you.
Yep. And of course, if they didn't do it, this doesn't mean their case goes away. It just means that there's an adjournment to the next meeting and they would have to post it repost it.
Okay, if there are any more questions on that, if not, we can jump into site visits for each of the cases. Okay, so what I'll do is I'll go through each of the cases by number and address, and just let me know if you did not have the opportunity to visit the site. So as you know, case number 1 was removed from the agenda. Case number 2 is 805-807 Bay Street. Are there any board members that did not visit the site? Okay. Case number 3 is 91 Prince Street. Any board members that did not visit the site? Awesome, very good. Case number 4, 235 Alexander Street. Any board members not visit the site? Case 5, 65-67 Thurston Road. Any board members not visit the site? 214, 216 Central Park, 37 Niagara Street. Case number 6. Any board members not visit the site?
Did not make it to that one.
Okay, anyone else? Okay, and case number 7, 29-31 Ontario Street. Any board members not visit the site? All right, very good. All right, so we can jump into questions on the cases themselves. Questions on 805-807 Bay Street.
Yes, I do have one. It has to do with Kyle Crandall's letter to us, the zoning board. He states on there that the original house was enclosed. And the owner doesn't state that. The owner is going by a map from 2007 when the property was purchased. The cellar was enclosed. Does anybody have any idea if that porch was enclosed when the house was built?
Generally speaking, the answer is no. Enclosed porches with some very rare occurrences were actually built enclosed, and typically you can tell by the windows or the age of the windows. The photographs provided from the state of the house when the owner bought it, as you suggested, seem to indicate that it was, it's at least at minimum been closed out at that time. But we don't, operate on the porch being enclosed as because it was not really a factor when houses were built.
Thank you.
Case number 3 is 91 Prince Street. So this case actually came to you all a couple of years ago. It was a different owner, and when a variance is granted, the applicant has a year to secure a building permit and get a certificate of occupancy. They basically have to act on the approval. Otherwise, the approval is void. So the previous owners, when you all saw this, did not act on it, and you don't need to have known of that case because this is a new owners, and they are looking to do what is essentially the same thing, which is establish use of the property as a 3-family.
Your voice is cutting out, Matt.
Can you hear me now?
Yes.
Okay.
It's in and out. It's in and out.
My audio goes in and out. Any questions on 91 Prince Street? Case number 4, 235 Alexander Street. Questions? Case number 5, 65-67 Thurston Road. Any questions on Thurston Road? This one did have some additional comments that came in last night from the 19th Ward Community Association that you all received. They're on the website just as a point of reference.
Yeah.
I have a question about this one. I got confused because she's talking in her documentation about putting in a new porch and how much that's going to cost and what does that have to do with?
Well, an applicant can claim, they can say they don't want to do something if there's some, someone may not want to do something because of costs associated with it.
Mm-hmm.
This is not a use variance, though. It's not a financial litmus test
Right.
in terms of finances. So what you'll want to do is, make sure to use the area variance standards.
Right.
To determine, but it is a good question because talking about finances seems to indicate that it's a financial hardship thing, but that's not what the code sees it as.
I have a question about that. And it's a financial question. I don't know if the owner had insurance that would cover that work or not. Is it right? Is it proper to ask the owner if that proposal, if that insurance would cover what should be done or what may have to be done?
There's not a financial hardship standard for this, but, you're looking at the benefit and the detriment. And, I think you could argue that if they have insurance resources, that there's not a lot of detriment to rebuilding at least some sort of porch there. So I think, they're saying they can't afford to rebuild. So, perhaps you could inquire as to an insurance, that might be a source of funding for it.
Thank you.
Any other questions on Thurston? Questions on case number 6, Central Park. This one also had some additional public comment associated with it.
Can't hear you.
Any questions on Central Park? I think I need a new laptop. And last case is case number 7, 29-31 Ontario Street. No public comment on this one. Any questions? Great, very good. Thank you all.
Well, Matt,
Yes.
I was trying to speak, but I guess you couldn't hear me.
Oh, no, I can hear you now, though.
As in regarding to K6,
Okay.
I've been involved with PCHO on several projects, and I would like the board to know I know the project very well, and I'm doing several other projects with this company, so I want to let you know that. I don't think.
Does your involvement impair in any way your ability to render a decision on the case?
No, I don't. No, not because it's separate properties that I'm involved in. But I think I may abstain anyway because people can say of my involvement with them on other projects. It may influence it, so it's hard to gauge on that. I'd rather just exclude.
So Dave, you're involved with the owner of this property or the developer? What?
The developer.
Okay.
We're developing some other projects and they're involved in. And I, because we have a relationship, I don't want people to think my relationship had anything to do with decision making. So I'd rather exclude myself totally from it.
Okay. We have a full board tonight, so.
Yeah, what you can do during that time, David, we'll just have you turn your video and audio off.
Okay. All right.
All right, very good. All right, thank you all. So this will conclude the pre-meeting for now, and then we will resume with the public hearing.